Let's shift focus now to the other big story. It's a huge relief for the AAM Aadmi Party and one of its senior leaders, Sanjay Singh, in the Liquorgate probe. The party's MP was today granted bail by the Supreme Court after 6 months in jail. Sanjay Singh was arrested back in October last year, and he faces charges of receiving as much as 2 crore rupees in bribes from one of the accused, Sameer Mahindru, and another of the accused, Abhishek Boinpalli. He has been in custody based on the statements of these two accused. In fact, the accused turned approver Dinesh Arora, who was one of the main people who was arrested in this scam. In fact, he was the head of Indo Spirits, which was one of the largest beneficiaries of this change of excise policy. However, the Supreme Court also said that given the inability of the agency to establish the money trail, Sanjay Singh has met the twin conditions of bail under PMLA. The AAM Aadmi Party has claimed vindication, while the BJP has said that Sanjay Singh has not been pardoned or he's not been let off the hook. This is not an acquittal of any sorts, even saying that the money trails have been tentatively established in the cases of Manish Sisodia and Arvind Kejriwal. Meanwhile, that was not the only thing that happened in court today. In what is a huge jolt to the AAM Aadmi Party, the Enforcement Directorate has countered Mr. Kejriwal's plea against his arrest, claiming that the party is a key beneficiary of the proceeds of crime, citing the 45 crores allegedly that was used for the Goa election campaign. The question remains, despite the relief from the Supreme Court, can the AAM Aadmi Party claim that it is off the hook and that the ED has completely confiscated this false case against them?
मेरे बेटे की आज रिहाई हो गई है बहुत खुशी है, दिल से खुश है। पूरा विश्वास था हमको कि मेरा बेटा तो निर्दोष है, ईमानदार है।
आप सत्य को दबा सकते हैं, लेकिन आप सत्य को मिटा नहीं सकते हैं। आज संजय सिंह जी की जमानत ने ये दिखा दिया। भारतीय जनता पार्टी का ये इरादा है कि आने वाले 2 महीने में लोकसभा चुनाव से पहले वो आम आदमी पार्टी के 4 और नेताओं को गिरफ्तार करने वाले हैं।
तो दिल्ली की गलियों से एक भावना आ रही है कि ईमानदारी की होती जो नीयत तुम्हारी, तो तिहाड़ तक न जाती तुम्हारी सवारी।
All right, let's go across to this face-off. It's a legal panel tonight on brass tacks. Sanji Unal is a lawyer. Sanjay Hegde is senior advocate with the Supreme Court. Mr. Unal, let me start with you. The court today has asked very pointedly to the Enforcement Directorate, where is the money trail? In PMLA cases, you have to be able to show that the said person was the beneficiary of received funds and that you're able to show that this was obtained through illegal means. And secondly, it has also said that Mr. Sanjay Singh has to go back to the trial court and the trial court will set the terms and conditions of the bail. So clearly, is this not a blow to the Enforcement Directorate? Because if it can't prove where the money trail is and recover these monies that it claims was used as kickbacks, then the case against Mr. Singh falls flat.
You see, after presumably 6 or 7 months, continuously roaming from pillar to post to get a bail in session court, trial court, then high court, then Supreme Court, then again going in the Supreme Court. Now he is able to get a bail, and especially categorically when asked from the ED, if there is any need of further judicial custody of Mr. Sanjay Singh, then ED advocate said, no, ASG, there is no need now. So while saying no from the ED side, he got a bail. And still, he is not free. Trial is going to take place in the coming time, and it will be definitely 1.5 years or whatsoever time it will take. So he is not free. He has got a bail, and categorically I told you when he has got the bail.
Okay, Sanjay
And law
Hegde,
can
this is
never
not an
be
acquittal
enforced.
by any stretch of the imagination. And B, the court has also specifically said that he can't, other accused in this case cannot cite this as precedent. So tomorrow, it doesn't mean that Manish Sisodia or others who are accused in this
Exactly.
case can go to the court and say that, look, you've given bail to Sanjay Singh, grant us also bail. So the court has clearly
This is
outlined
very,
that.
exactly.
See,
It's
the
very
first
important.
thing
Moreover,
is,
Yeah,
okay.
Sanjay Hegde.
see, the first thing is that the ED conceded. The ED conceded after it was asked a very important question by the bench. The bench says that you have kept him in custody for 6 months. Dinesh Arora initially implicated him. Later on he did. No money has been recovered. The trace of money is not there because it was long back. Fact of the matter is money has not been recovered. Please keep in mind that if we are with him, we are required to record in terms of Section 45 that there has been prima facie not committed an offense. That could have its own ramifications in trial. To decode it for your viewers, the Supreme Court basically asked the ED's lawyers, if we grant him bail, it will mean that prima facie there is no case. That would mean that your trial would possibly fall. Take instructions and come back. Why do you need him in custody? And that's when at 2:00 the ED lawyers came back and said, oh sir, we don't need him in custody. We don't go into the other questions without making this a precedent so that the others can't cite it as a precedent. In this case, grant him bail in the peculiar facts. So a very pointed question being asked, there being no specific reply in the facts of this case, the ED had to concede after fighting tooth and nail over 6 months. This could have very well, this raises questions. Was arrest necessary in the first place? The ED basically goes around saying off with so and so, off to jail, something out of Alice in Wonderland. This kind of routine arrest and abuse of the arrest provisions is what is making the courts ask questions. Today, the Supreme Court has asked pertinent questions. I have no doubt that the ED will be asked many more questions in the further court proceedings whenever Mr. Kejriwal or anybody else.
But Mr. Sanjay Hegde, in a separate matter before the Delhi High Court today, the ED has also contended that the Aam Aadmi Party as a political entity was the major beneficiary of proceeds of crime, that money laundering was done through the Aam Aadmi Party. 45 crores of these proceeds of crime were utilized for the Goa elections. And if you remember, in a separate hearing that happened a few weeks ago, even the Supreme Court had asked, why aren't you making the Aam Aadmi Party a party to this case? So it's not like either the Aam Aadmi Party or its senior leaders have been let off the hook.
Nobody has been let off the hook. But the point is that bail was very difficult to get in cases under the PMLA, as it is difficult to get in the UAPA or NDPS. So with this high bar for granting of bail, it was difficult. And therefore, when the Supreme Court asked pointed questions and has indicated that the case against certain individuals seems to be prima facie not there, the ED dared not take that judgment in an order. If the ED was so convinced of its case, it would have said, oh, please let us argue, you pass a judgment.
Okay.
The ED chose not to take that risk. The ED also knows how insubstantial its case is, at least in Sanjay Singh's, because that's the only inference that you draw when the ED comes back and says, okay, we will not oppose bail, and you may grant it.
In fact, one of the few
other questions are not asked.
Yeah, one of the few conditions whereby in PMLA cases one can get bail is if the prosecuting agency, the investigating agency, does not oppose the grant of bail. So Sanjeev Unal, by doing so, when the bar is set so high, hasn't the ED conceded, as Sanjay Hegde is arguing, that it has no case against Sanjay Singh?
If there was no case, sometimes I ask this question from myself. Then the moment ED has registered a case against him, would have been given a bail. in the first instance. After 7 days of his taking custody by the ED, then he has gone into the court, but nobody has given him a bail.
No, because the
So
bar
first of
for
all,
bail
it
is
a-
set high
not an
under
argument.
PMLA. For any other provision, the
No, then
bail is
this
the
is-
norm and jail is the exception, but
So,
not in the case of PMLA.
Jacob, still he is still under custody in this matter only. Then why he has got this bail after 6 months? If bail is not a right in this case, why he has gotten bail? It means bail
Because
could
the
have
ED
been
conceded.
taken 6 months back also. Now, I have 2 points mainly. If the person who is making this case, Section 50 of PMLA, Section 19 of PMLA, clearly signifies that you are not innocent till feel guilty in other criminal matters. It is a different set of, entirely different set of sections are embedded in this. And it was, governed in 1955, not by the BJP government or the present government. So 1950 point law was tiger without teeth. Now this is teethless tiger. Now exactly ED has power. ED know what is his power. So it was a almost sleeping tiger in those days.
Okay.
So the cases are very strong against all the AAP MLAs, even the
No,
against the
I must remind you
chief
and our
minister
viewers
also.
that the amendments that were made in 2018 were the ones that set the bar for bail so high, and where it effectively said that the onus of proving innocence is on the accused and not the onus of proving guilty is on the investigating agency. But we'll leave it at that. Thank you very much to both our guests.